A person with a disability or with special needs, if they receive a sum of money, whether that's from inheritance or from a lawsuit, it could affect their ability to qualify for government needs-based programs, including things like Medicaid and Social Security income. The purpose of a supplemental needs trust is to provide for a beneficiary with a disability or with special needs without impacting their ability to continue to receive government benefits. There are several types of special needs trusts that are typically broken down into two categories: a first-party special needs trust and a third-party special needs trust. A first-party special needs trust is set up by the special needs individual, and this is often a result of receiving a sum of money from a lawsuit, maybe a personal injury matter or a medical malpractice matter. And this can be a trust that is set up and designed to provide for their benefits without affecting their eligibility for government needs-based programs. And again, it's set up by the individual with special needs or a guardian or a power of attorney on their behalf. A third-party special needs trust, as the name suggests, is created by a third party. This is somebody other than the disabled or special needs beneficiary. And it's often in the context of estate planning. When you're considering incapacity or death and you're trying to structure your estate plan to avoid an outright distribution going to a special needs beneficiary, which would disrupt their ability to qualify or continue to receive benefits. So instead of having funds go directly to that person, we place them into a trust, and the trust is restricted in how it's used, but specifically restricted so that it doesn't prevent that beneficiary from being able to qualify or continue receiving benefits. There are fairly strict limitations on how the trust assets can be used for the beneficiary. So the idea is that these assets are used to supplement, not supplant or not replace the needs of the beneficiary, which are being provided through benefits programs. So for example, the trust assets are typically used for education, leisure, recreation, and comforts that are not provided through public assistance. It's worth mentioning that many states offer what's called an ABLE account, Achieve a Better Life Experience. This is a statutory trust that is different from state to state, that allows someone to set up an account and they put money into that account, and it has the same effect as a special needs trust in the sense that it protects those assets from causing a disruption to the beneficiary's ability to receive benefits, but it allows distributions on behalf of the beneficiary to pay for certain restricted things like we talked about earlier. There are differences, however, that you have to consider when you're deciding whether an ABLE account is sufficient or if you're interested in setting up a special needs trust. For example, there are contribution limits. You cannot give more than a certain amount toward an ABLE account in a given year, and there are total cap limits. Once you go above that cap limit, the excess assets in the account could cause a disruption to the beneficiary's ability to receive benefits. So those are things that you'd want to consider. And if you're thinking about setting up either an ABLE account or a special needs trust, you should absolutely talk to an attorney in your state that can help advise you through the process. I hope that you found this content helpful. If you did, please let me know, and I'll look forward to seeing you in the next episode.